Let the record reflect, state's attorney's present, defendant and defense attorney are present. Is there anything we need to take up before we bring the jury in this morning?
That was taken. No, ma'am.
All right, you can bring the jury in. Yeah, it's 66 in here today, which is what it's set at. But yesterday it was set at that and it wouldn't get below 70.
It was like, yeah.
So I'm just gonna leave it and
Keep them up.
I know, do you have your
I got my blanket on.
your hand warmers? Good morning. Let the record reflect the jury seated, state's attorney's present, defendant and defense counsel are present. Mr. Coleman, you may call your next witness.
State called Dr. Rajesh Anand. Yes, sir.
Yeah. Good morning.
Good morning.
Could you please raise your right hand? Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can have a seat.
Steve John.
Yes, you may.
Good morning, doctor. Would you please state your full name for the court reporter and the ladies and gentlemen of the jury?
Yes, my full name is Rajesh Kannan, Rajesh, last name Kannan.
And Dr. Kannan, how are you employed, sir?
Right now, I am employed as a forensic pathologist here at the Forensic Medical at Beaumont.
And are you a licensed medical doctor in the state of Texas?
Yes, that's right.
And your background that has led you to hold this position, what does that include, sir?
Yes, just like any other medical doctor, I went to medical school. And after graduating from medical school, I further did 4 years of training in pathology residency. And this was at Robert Wood Johnson University Hospital in New Jersey. And after doing 4 years of residency, I further specialized in forensic pathology, which we call as fellowship. That's for a year. And that I did in Bexar County Medical Examiner's Office in San Antonio. So that's total of 5 years of training after medical school. And then I got board certified in the American Board of Pathology in forensic pathology. So I'm a board certified forensic pathologist.
And I know you're not wanting to toot your own horn, but with regard to gunshot wounds, what, if any, specialization, research, or publishing have you done in that regard?
Yes, gunshot wounds are also part of injury. Generally, as a forensic pathologist, we are experts in interpreting injuries and deciding cause and manner of death. And in my training in Bexar County, I trained under Dr. Vincent DeMaio, who was author of Gunshot Wounds of several textbooks, and he's one of the world-renowned forensic pathologists, and I trained under him.
Now, you mentioned forensic pathology a couple of times. Please briefly explain to the jurors what forensic pathology is.
Yes, forensic pathology is a field of medicine, just like any other specialization. If you go to a cardiologist, they specialize in cardiology. So we specialize in forensic pathology, which is different from hospital pathology. So we are trained to do death investigation. We put everything together and we look at everything, including what happened at the time of death. And we do a complete forensic autopsy, which is part of the examination. And we finally come to a conclusion and come up with a report and then cause of death and manner of death.
And are you associated with or work for or consult with the Forensic Medical Management Services here in Jefferson County?
Yes, that's how I'm currently employed.
Okay. And as part of that, do you perform autopsies?
Yes, I do.
Have you performed autopsies on few or on many occasions?
I have done several autopsies in approximately 20 years of my career, about 4,000 or so.
Okay, so I'd say that's me. An autopsy, for the ladies and gentlemen of the jury, just briefly, I mean, is there a standardization or a process associated with performing an autopsy?
Yes, like I said before, forensic autopsy is very different from other autopsies. It's like going to a doctor and he does a physical exam. So we look at everything from outside and then we document with photographs, and also while doing documentation, we are trained to look for injuries. So when we see injuries, we take extra photographs, document, and then look at all the organs, chest, abdomen, pelvis, brain, and further look at injuries in the inside and then document again.
You've testified in court undoubtedly over the course of your career, correct?
Several times, yes, sir.
And have you testified as an expert witness on occasion?
Yes.
And I'd like to shift gears now to March the 30th of 2022. Was a forensic autopsy conducted on an individual identified as Richard Shiloh?
Yes, sir.
Okay. And you were not the doctor who performed that autopsy, correct?
Correct.
That would be a Dr. Sally Strouch Rivers, correct?
Correct.
And as far as you know, she's no longer employed by Forensic Medical Management Services, correct?
That's right.
But nevertheless, you have reviewed her report, photographs, and the file. And is it your opinion that there is sufficient information contained in those photos and in that file for you to render an opinion?
Yes, I looked at everything all over again and came to my own conclusion. Yes.
Essentially conducting what's tantamount to a peer review of what she did, right?
Yes, that's right.
And did it appear that the proper protocols were followed? I know that there are some things that you have a differing opinion on. We'll get to that. But as far as the overall protocols, do they appear to be adhered to?
Yes, the autopsy was done, toxicology was done, and everything was done.
And have you reviewed the work of other pathologists and testified about their conclusions or your opinions based on their report? Have you done that before?
Yes, I worked in Bear County for 14 years as an ME deputy, and our training program there. We train forensic pathology like us, so I routinely review their cases. When somebody leaves, we go and testify on their behalf. Yes, sir.
And as an employee of Forensic Medical Management Services, you undoubtedly have access to the report, the photos, what we lawyers refer to as being a custodian of record for those documents, correct?
Correct.
Okay. Let's talk about the external examination that was conducted with regard to Mr. Shiloh. What did that indicate?
So the external examination indicated that the deceased was attended the hospital and admitted very briefly, and then they came over to us. And on examination, the doctor who performed found injuries on the individual.
Was there any radiographic imaging done?
Yes, we also take X-rays to look for any projectiles.
What, if anything, was indicated as it relates to the radiographic imaging?
Yes, they did find a bullet which was still in the body, and another one in the body bag.
And we'll talk about how, or what your conclusion or opinion is as to how that bullet ended up in the body bag. We'll talk about that later. But as far as actual gunshot wounds, there were a total of how many?
2.
And where were they located?
Yes, the number one gunshot wound, or in the order of top to bottom, was on the left side of the body, which is the chest. And it was actually very close to the back, right at the edge.
And the other gunshot wound?
Other one was on the lower back.
And if I represent to you that there was testimony that indicated the deceased was in a vehicle, excuse me, sorry, apologize for turning my back to you, but seated in the driver's seat, and that the possible shooter was at the back rear passenger door, what, if any, explanation would you offer as to why there would be a gunshot wound in the left side of the deceased?
Well, when we look at the body, we always describe in the standard anatomical position, which is standing up with the palms facing forward. But I always tell that when somebody is getting shot, they're not going to do that. There'll be movement. So if the body gets twisted either this way, or left or right, the bullets can go any direction on the body's facing.
So the body's not static. In other words, would it be possible if a firearm is introduced, the victim sees the firearm, again, body doesn't remain static. Would it be possible if that individual turned to shield him or herself away from the fire of a firearm? Could that possibly explain why there's a shot there in the left side?
Well, I can't really tell what the deceased is going to do, but all I can say is if there's a twisting of the body, then the bullet will go in that direction.
Yes. Let's talk about the nature of that fire or that bullet defect or wound on the left side of the deceased, Mr. Shillow's body.
Yes.
What distinguishing characteristics did you observe with regard to that?
Yes, so based on my observation of the evidence I had, this particular entrance wound is a type we classify as a contact wound, meaning the muzzle end, which is where the bullet comes out, is touching the clothing if they was wearing one, or the skin. So it's not far away and it's not very distant. It is touching. So we call it a contact wound.
So whoever shot Mr. Shiloh pressed that gun against Mr. Shiloh, in your opinion, and pulled the trigger.
Correct, based on the injury.
Now, let's move on to the gunshot in the back. For whatever reason, well, you explained the nature of that.
Yes, so that wound does not have any evidence. In the other wound, the evidence we had was black soot. So when the firearm is discharged, it's not just a bullet which comes out. Along with the bullet, there is a flame, there is unburnt gunpowder and black soot which comes out. So that's deposited if the gun is in contact with the skin. And then if the gun is far away, which is, we don't know how far, then none of that evidence will be there. So that was found in the second one, which is in the lower back, which was a distant one.
And did you form an opinion as to that particular gunshot wound and the loose projectile in the body bag?
Yes, so the only way I can explain how one of the projectile, which we can talk about, to the number one gunshot wound on the side, went down and got embedded or lodged in the right leg, which was collected. And then, so the other explanation for the loose bullet is based on the defect. The bullet entered the back, but didn't really do much. So it kind of somehow lodged into the skin. And then during the transport, it got dislodged and collected in the body bag. That's my explanation.
Let's move on to the internal examination. What, if anything, noteworthy was the result of the internal examination?
Yes, so based on the observation externally, so we start looking in the internal side and see what trauma this gunshot wound did. And so we also look at other organs, make sure there's no other damage.
Now, here's where you, as I understand it, take issue or have a differing opinion than Dr. Rivers as to the internal or the trauma caused by the projectile that entered through the left side. Is that fair to say?
Yes, yeah. The bullet enters the left side, and then so basically it comes. I can stand up and show. So it's coming here and then goes down here. So it's traveling in a downward direction, left to right. So it's like drawing a line, point A to point B. So we kind of track what's happening in between. And then while doing so, I observed based on the photographs, there was blood accumulation in the pelvic cavity, which we call where the pelvis or the lower part of the abdomen is. So, and then it enters and damages the intestine, stomach, diaphragm, which is a structure which is useful for breathing. So all those structures are injured, and then a lot of blood accumulation in the abdomen. So the only way blood accumulates is when a bullet damages a blood vessel. And if you think about it, in living individual blood vessel, we have blood pressure. And then once a bullet injures a blood vessel, it's like a hose pipe. I usually describe with a hole. It's just blood is just going to pour out. So that's why in my opinion, blood accumulated there. And then after doing that, bullet travels downwards and lodges in the posterior thigh, and where it was recovered.
Now, was that how Dr. Rivers described it, or?
There was no explanation of how the blood accumulated.
So is that kind of where you differ or you take issue, or you think there needs to be further explanation? I don't want to put words in your mouth. What's your take on that?
Yes, yes. So based on, I've done about 4,000 cases and lots of gunshot wounds, and being in a big city in San Antonio, I've seen many of this. And in my explanation, the way the blood accumulated and the amount, in my opinion, is because of blood vessel injury.
And there was no mention of a
No.
blood vessel injury in her report.
Correct.
Thanks for pointing that out. And nevertheless, do you concur or agree with the cause of death?
Yes, the cause of death doesn't change. In this particular case, do you?
Please.
Yes, the cause of death in this particular case is gunshot wound to the chest with the resultant hemorrhage.
Now, there's a difference. It's a distinction that people in your industry, in your field make. There's the cause of death, and then there's the manner of death.
Yes.
What's the manner of death?
Yes, the manner of death is based on. So eventually, what happens is, if I work in a medical examiner system, I have to certify the death certificate. And here, the justice of the peace does that part, since it's the justice of the peace jurisdiction. So the manner of death is classified as natural, accident, suicide, homicide, or undetermined. And that is a death classification.
I'm sorry to interrupt. It's essentially a checkbox.
Checkbox, correct. So we have to classify the death. And in this particular case, the manner of death is classified as homicide.
But nevertheless, the cause of death was by gunshot.
Wound, hurt.
Gunshot. You mentioned as part of the file, there were certain photographs. You reviewed those photographs, correct?
Yes, sir.
May I approach the witness, Judge?
You may.
Dr. Panorama, I'm going to show you what I've previously marked as state's exhibits number 42 through 54, and ask you to take a moment to look at those and tell me, please, if you recognize those from the file, your review of the file.
Yes, sir.
Do they appear to be true and accurate copies of the photographs that you recall from your review of the file?
Yes, sir.
They don't appear to be altered or have been manipulated in any way?
No.
Your Honor, at this time, State Office States 42 through 54, they've been previously provided to the defense counsel in discovery, and for the record, I'm tendering to him for his discussion. Have a moment.
Sure.
Judge, the only objection I have is that these are business records and he hasn't established them as the custodian of business records since he actually did not want the autopsy.
That's overruled. States 42 through 54 are admitted.
Commissioner Police Judge.
Yes, sir.
For the record, doctor, I'm showing what's been marked as State's Exhibit number 42. This tag here, what does that indicate?
So each case which comes to the office gets a unique identifying number. And it starts with the year first, in this case 22. And then after that, it's a sequential number 327. And then BMT stands for our branch. There are several under the group, which stands for Beaumont. So this particular case, we are trying to establish is connected to this individual.
And that number or unique identifying number is next to a armband here, is that fair to say, in State Exhibit 45?
Yes, that's right. That armband, because he went briefly to a hospital. That's from the hospital. So we are trying to establish the connection.
Okay, and here it's, oh, it indicates that that number is associated with the Richard Shiloh, correct?
Correct.
Here in States 43, we have, what do we have here?
So this is called an intake photograph, meaning when the deceased come to us, we photograph how we receive passes.
And States 44 is essentially just a close-up of that initial or intake photograph.
Yes, sir.
And for the record, it's still in that body bag.
That's right.
States 46, what are we looking at here in States 46?
This is the left side of the body, and then there's a tube which is inserted at the hospital, and then they're trying to put a ruler to photograph an injury.
And speaking of the injury, States 47, is that a close-up of that injury?
Yes, but this has a glare on it, and we have a better picture.
Look at that better picture. Now, is States 51 a better representation of that photograph?
Yes, this is a cleaned up photograph, and the roller and the wound is beneath the roller, and what you see centrally is the gunshot wound, and the black area around is the soot I talked about, which is indicated as a contact close gunshot.
Is States 52 a better representation, or at least a closely and zoomed in?
Yes, that's right. It's a close zoomed in picture, and then the central defect, what you see is the actual area where the bullet enters, and then the surrounding area is the black soot.
This surrounding area here,
Yes, sir, that's the soot.
again indicating that that firearm was pressed against this individual
Correct.
when it was fired.
Yes, right.
States Exhibit number 53, what are we looking at there, doctor?
So this is a picture of the back. And the top of the head is on the left side. And then there is a ruler again, and then there is a white area, which is the defect. So this is the other gunshot wound to the back.
And States 54, is that just a close-up or a zoomed-in shot of that bullet defect to the back?
Yes, it's the same area. It's the same second gunshot wound to the back.
And States 49, is that the projectile that you believe worked its way out of the back into the body bag?
Yes, this is the loose projectile, a spent projectile, meaning it's fired from a weapon, and that's found in the body bag at the time of examination.
And lastly, States Exhibit number 50, this is just a photo of Mr. Shiloh's face, correct?
Yes, it's like an ID shot. We tried to take a little bit of cleaned up picture.
Very good. Did you find, or was there any indication of any disease or of any disease that would have otherwise prevented Mr. Shiloh from continuing to live?
No, there was a complete autopsy done, which means they examined the heart, lungs, kidneys and other organs, and based on my review, I did not find any other evidence of disease.
And is it fair to say, based on your training and experience, that a firearm is considered to be a deadly weapon capable of causing serious bodily injury or death?
Yes, it can.
And in fact, it did cause death in these cases, correct?
That's right.
Thank you, Doctor, for being here today. Your Honor, that's all the questions I have. I'll pass it to you.
Thank you, Mr. Coleman. Mr. Radford?
Doctor, could you pronounce your name for me, please?
Yes, sir. First name is Rogers, last name Cannon.
Ken?
Cannon.
Anna, oh.
Yes, sir.
I have a few questions for you. Do you, when you reviewed the records, did you notice whether or not any gunshot residue tests were performed on Mr. Shiloh?
I did not see any evidence. There's a paper bags, but right now we actually do them if there is a request from the police department.
Okay.
I can't be really sure on this case.
You don't know?
I don't know, sir.
Okay. Did you look at the toxicology?
I did.
I'll go over that with you. The toxicology is when you test the blood to find out what substances may be in his body, correct?
That's right. In the autopsy, we take blood samples and send it to a lab. They do a comprehensive test and then give us a report.
I'm looking at page 3 of the NMS labs. It shows that there were barbiturates in his system, correct?
I'm looking at the NMS lab positive findings, which is where we look for the results.
Mhm. You see where it shows that there were barbiturates in his system?
It's a hospital induced substance.
Okay, what are barbiturates?
Barbiturate is a very old school type of drugs, and usually it's given in hospital settings. This medication for analgesic activity or a hypnotic activity.
It can also be on the street, can it? It's also a street.
But yes, but not all of it. In this particular instance, the drug etomidate, ETOMIDATE, is usually administered in the hospital setting.
What about cannabinoids?
Cannabinoids, yes, but in this case, they did not report anything.
It doesn't say 10 ng/ml under barbiturates.
So I'm looking at the positive findings, and there are only 3 drugs identified in the first page of the report, which is caffeine in this case, cotinine, which is another product of coffee, and then third is etomidate, which is a drug given in the hospital setting.
Go to page 3, if you would.
Yes, sir. So those are reporting limits, meaning they are looking for it, but in this case, we don't have it.
There's no, they didn't find cannabis?
No, sir. So it's all should be in the findings if there is any.
What about acetone,
They did not find any.
ethanol?
No, sir.
So he just had caffeine, cotinine, and what is,
Etomidate, which is, like I said, a substance given in a hospital setting.
what is cotinine?
It's just a product of a coffee material.
That's all I have there.
Thank you, Mr. Radford. Anything else, Mr. Coleman?
No, Your Honor.
Any objection to Dr. Khan being excused?
Not at all. No, ma'am.
Thank you, doctor. You're excused.
Thank you.
And you're placed under the rule, and you know what that means.
Yes,
Thank you.
thank you.
You may call your next witness.
This time state calls Alize Ballard.
Alize Ballard or Ballard. Yeah, they were, they're getting her from upstairs. I just got a message.
Okay.
Good morning, ma'am. Before you sit down, if you'll please raise your right hand. Do you swear? Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, ma'am. You can have a seat. And so I'll just ask you to kind of pull that microphone and get as close as you can. Make sure you speak loudly and clearly so everyone can hear you. Also, if it's a yes or a no question, be sure to say yes or no and not just an uh-huh or a head nod so that the court reporter can take everything down.
Yes, ma'am.
Thank you. You may proceed.
Thank you, Your Honor. Good morning. Do you pronounce it Ballard or Ballard?
Either way.
Okay, Ms. Ballard, would you please state your full name for the court reporter and the ladies and gentlemen of the jury?
Alize Ballard.
And that's spelled Alize, right? The first name?
Curry.
All right, and I don't need the address, but what city and state do you reside in?
Beaumont, Texas.
Okay. And how do you or did you know Richard Shiloh?
We were in kind of like a romantic relationship.
In fact, you didn't call him Richard, you pronounced it how?
Richard.
Richard Shiloh. And were you in a dating relationship back in March of 2022?
Yes.
And I want to take you back to that day in March, on March 27th of 2022, when Richard was shot that day. During that time, what type of a vehicle did he drive?
A red Cadillac.
At around 7 p.m. That day, would you have been on the telephone with him?
I was.
And I want to kind of walk through that telephone call with you for the benefit of the jury. You indicated that you knew that he was backing that Cadillac up during that conversation. And how would you have known that?
I heard the little beep sounds whenever we back up and like whenever you're close to something.
And after hearing the beeping sounds, you indicated that you heard him talking to other people, correct?
Correct.
You don't know who these people are or were, do you?
No.
And what did he tell you he was about to do?
Pick up some money.
And did he tell whoever he was talking to go to the other side of the car?
Correct.
What did you hear next when he told them to go to the other side of the car?
I heard rumbling and I heard the phone a distance and I heard him like saying stuff and then he started swearing, saying F-U-C-K continuously until he heard my voice.
And at some point, did he yell out what
Happened.
what happened to him?
Yes.
What did he say? And I know the language is kind of rough, but what did he say?
This nigga just shot me.
Okay. And after that, did you hear anything else on that telephone line?
He hung up.
What did you do next?
I kept calling him back. No answer. Got in my car and tried to find him.
Did you eventually make your way to the Virginia Estates Apartments that evening?
I did.
This jury's already seen the body worn camera video, surveillance video, so they know what that scene looked like that afternoon or that evening. But nevertheless, you couldn't get past that the tape, right?
Correct.
That they marked off the scene. Eventually, did you talk to an officer or officers there at the scene?
Yes.
Did you tell them essentially what you're telling this testifying to this jury today?
Yes.
In fact, after talking to those officers at the scene, at some point, did you come into the police department and talk to a detective?
Yes.
And did you tell that detective what you told the officers at the scene and what you're testifying to this jury about today?
Yes, sir.
Did you go to the hospital that evening?
No.
But at some point you found out what happened to Rashard.
Oh, I'm sorry. I'm think you're saying for me. I apologize. I did go to the hospital.
And when you went to the hospital, did you find out what happened to Rashard?
Yes. No, I found out at the police station.
Okay.
That's when they let me know.
And they told you that he died.
Right.
We've seen some photos, some unfortunate photos of Rashard. I'd like to. May I push the witness?
You may.
It's important for this photo, for the jury to see this photo. I'm showing you what I'm marking as State's Exhibit number 55. Do you recognize that photo?
Yes.
Do you recognize the individual in that photo?
That's for sure.
Yeah, is it fair to say that this would be a fair and accurate depiction of Rashard?
Yes.
Throughout this time, State Officer State's 55, tendering to defense counsel. For the record, this would be a fair and accurate depiction of Rashard when he was alive, I should say.
Yes.
Tendered, State's 55 to defense counsel.
No objection.
Stays 55 minutes.
Permission to post, Judge.
Yes, sir.
That's Rashard there.
Yeah. Yes.
Part of what I've got to do is I've got to identify him for the record. Make sure the record's clear that we are talking about the same person. Just let me know when you. Just let me know. And again, for the record, I have to make sure that we are talking about the same person who was deceased that day. Is this also Rashard?
I can't see that.
Judge, I think that's all I have.
Thank you. Hang on just a second, okay?
You want me to take a break?
So Mr. Rapper's gonna have some questions for you. Do you need a quick break?
Please.
Okay, but we're gonna take just maybe 5 minutes and then we'll get you back in there. Go take a break real quick. You'll make sure that get Steve to go, just keep it. Yeah, that'd be good. Let's do that. All right, ladies and gentlemen, let's just take about a 5-minute break. It's 9:45. Just kind of step out, stretch your legs for a little bit. We'll get you back in here in just a minute. Thank you. All right, we'll be in a short. President, defendant, defense counsel are present. You can bring the jury back in.
You said that you're seated.
Oh, did I? I did say that. Let the record reflect the state. I said the jury's seated. I don't know. They're not here for the record.
I didn't hear.
That just shows that there was one person paying attention.
Yes, exactly.
I heard it, but I wasn't.
Got ahead of
He
myself.
pulled me out, he threw me off. I was like, "Never else."
Judge, do we have a weather contingent for tomorrow afternoon if it gets bad, or I don't know what the.
Not gonna get bad.
Oh, that's good.
Gonna rain. Normal rain, a
Oh,
little bit of wind. I'm keeping up with emergency management's keeping us informed, so. All right, now let the record reflect that the jury is seated, state's attorneys present, defendant and defense counsel are present. It's the Radford, you may proceed.
Ballard, my name is Wendell Radford. I'm just gonna ask a few questions. Okay. How long had you and Richard been seeing each other?
Since I would say 9 months.
And you were on the phone with him at the time.
Yes.
Did you know where he was going?
No, I didn't.
But you said that you heard him tell somebody to go to the other side of the car.
Correct.
Was that before or after you heard the beeping sound?
That was after the beat.
And then you said you heard some argument.
I heard the phone going to a distance, and I heard his voice like talking to someone and telling them like, "Oh man, something." I couldn't really make out what he was saying, but he was like sounding distressed. So I heard him saying, "Fuck, fuck, fuck." He kept saying
So
it.
they were having some kind of
Yeah.
heated conversation.
Well, it wasn't a conversation. It was like as soon as he got parked, everything happened.
Okay.
Like
Did you
within
ever-
a minute.
Did you ever see or know of Richard to carry a gun?
No.
You know, can I have a moment here?
Sure. Your gun, if you're looking, are you looking for the gun?
It's not.
It's not an
It's
evidence.
not admitted by stipulation. By agreement.
That's all right. I mean, he's gonna have to put it in later anyways. So, but you never saw Richard have a gun?
I never saw him. I seen him with a gun one time, but not multiple times.
Do you remember what the gun looked like?
Yes, it was long.
Long gun?
That's all I remember.
You have that picture? I'm gonna show you what has been marked. Come here, bro.
Sure.
I'm gonna show you what's been marked as states 33 and 34. Does that look like the gun that he had?
I would honestly, it's been so long ago. I just know it was long. I didn't pay attention. I'm scared of guns.
Okay.
No objection if you want to offer.
Yeah. That's all I have, Judge.
Anything else, Mr. Coleman?
No, Judge.
Any objection to Ms. Bullard being excused?
No, ma'am.
So, Ms. Ballard, you're being excused, but all the witnesses are placed under what's called the rule. And what that means is you're not allowed to discuss your testimony with anyone else involved in the trial other than the lawyers or the investigators. Also, you're not allowed to be in the courtroom during anyone else's testimony, and you're not allowed to watch any of the proceedings on YouTube.
Okay.
Okay, thank you. You're free to go.
Thank
May I call your next witness?
They call Detective Nicholas Thomas.
you.
Good morning. you please raise your right hand, sir?
Yes, ma'am.
Do you swear from the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can have a seat. You may proceed.
Thank you. You please state your full name for the court reporter and ladies and gentlemen of the jury.
Nicholas Thompson
And Detective Thompson, how are you employed, sir?
with the City of Beaumont, Beaumont Police Department.
And are you a certified peace officer?
Yes, sir, I am.
Your training and background, what does it include?
Ooh, I've been a police officer since 1999. Kept up with the yearly mandates, standards, additional training. Part of the department SWAT team, additional training and all of that, so very extensive.
Your involvement in this case, it was fair to say, was limited, correct?
Yes, sir.
Did you, in fact, you just essentially sat in on an interview, a witness interview, is that fair to say?
Yes, sir.
My questions are more general in nature, related to law enforcement, generally speaking. So, starting with your understanding as in your training experience, what a drug rip is. Explain to the ladies and gentlemen of the jury what's commonly referred to as a drug rip.
Usually it's an interaction between individuals where there's going to be an exchange of narcotics, at which point one side or the other takes the opportunity to take the items, the illegal narcotics, from the other one without payment.
In your training experience, why is that? Why would someone choose to do that?
Objection, speculation.
Well, let me ask it a different way, Judge. In your training experience, do drug dealers who get robbed go to the police to report their stolen drugs?
No, sir.
Okay. And is that one perhaps reason why people would choose to rob a drug dealer?
Yes, sir.
Next, I want to talk to you about certain surveillance video from the Virginia Estates apartment complex from March the 27th of 2022. Did you have an opportunity to review at least a couple of those clips from that apartment complex?
Yes, sir, I did.
And did you, after reviewing the clip, rewinding it, slowing it down, did you form an opinion as to whether or not one of those individuals was carrying an object?
Yes, sir, I did.
And what is that opinion?
As the individual that was fleeing the scene had a long object extended from his right hand.
Hard to make out because of the quality of the video.
Yes, sir.
It did look like a long object though.
Yes, sir.
Could it possibly have been a firearm?
Yes, sir.
Okay. In fact, I'm gonna try to cue up those two instances of spots in these videos, if you bear with me. For the record, I'm going to publish States Exhibit 26 that contains the videos from the Parliament conference. Queuing up video 11-03-27-22, excuse me, 2022 19-20. And again, detective, you have the benefit of being able to watch, rewatch, rewind, slow down the video. And this is already in evidence if the jury refuses to watch for themselves, but you formed an opinion. And I want you to tell me when to pause it, and you tell me what, if anything, you observe.
Yes, sir. Right. So right there appears to be on the right side, going down towards the foot along object.
And we're talking for record purposes, about 7 minutes and 58 seconds into the video. Um, what hand does it appear to be in, left hand or right hand?
The right hand.
We're talking about the individual in the lead there, right?
Yes, sir.
The one with the black pants with the red stripe on it.
Yes, sir.
Uh, uh, if there's a way for me to blow it up, I blow it up. But again, you have the benefit of being able to look at it closer than what perhaps the jury can see from their vantage point. All right.
Yes, sir.
No. There's a physical pointer. I don't know if I can go on this screen, but if you could stand up and show the jury, at least in your opinion, where and what you see.
This individual right here, extending right there on the right side of their body down towards the foot.
Okay. For the record, I'm publishing 13-03-27-2022, 19-27-19. And like before, detective, tell me when to hit pause, when you observe something that you think is noteworthy for the jury.
Yes, sir. Pause.
You need me to run it back a little, or is that fine?
Just a little bit forward.
Forward?
Yes. Sir. Right there.
Is that fine?
Yes, sir.
All right, you can use that pointer now if you want to point out and describe for the jury what it is you're pointing to.
Again, in the gentleman in the front, or the individual in the front in the right hand, appeared to be an item extended from the hand down towards the foot along the leg.
Again, hard to make out,
Yes, sir.
but again, you've watched it several times, slowed it down, paused it, and you formed an opinion.
Yes, sir.
firearm, in your training experience is considered a deadly weapon,
Yes, sir, it is.
capable of causing serious bodily injury or death?
Yes, sir.
The other individuals in that vehicle, who did they include in the way of being identified as? If you know, or if you can refer to your report,
From that vehicle, no, sir.
are there? And if you don't know, you don't. But,
Yes, sir.
but were there any other individuals from that incident or from that vehicle, that silver Infinity? Were they linked to the discovery of a longish type firearm?
Yes, sir.
And if you've got your report, if you refer to your report this time, who were those individuals and what were their names?
No, so in my report, I have a Ronald Babineau, Charles Verdine, Kalon Johnson, Javon Johnson, and Trevor Green.
And they would have been linked the very next day to a long type firearm.
Yes.
Okay. That's all the questions I have to ask.
Thank you. Mr. Radford?
Detective Thompson, you actually spoke with Ronald Babineau, didn't you?
Yes, sir.
And did you work with the other detectives on this case?
Initially, in the beginning, I did, sir.
And that would have been Detective Hamilton, I think,
Yes, sir.
and then also Detective Tamayo.
Yes, sir.
And you talked to Ronald Babineau. And I think you talked to Charles Verdine, didn't you?
Yes, sir, I did.
And after visiting with them, did you ascertain that Ronald was driving that car today?
Yes, sir, I did.
And that Charles was with him?
Yes, sir.
And also Kalon Johnson, he ultimately was determined to be the shooter, isn't that correct?
That was determined after my.
After your involvement?
Yes, sir.
Were you involved when it was determined that Joseph Freeman had been shot by Richard Shiloh?
No, sir.
Was that Detective Hamilton and Tamayo?
Yes, sir.
Because I think you were on a different case involving Babineau, Verdine, Kalon Johnson, Javon Johnson, and Trevor Green, correct?
Different case.
That happened on the 28th, the next day. Were you assigned something about a stolen vehicle?
That was part of this investigation.
Okay,
Yes, sir.
but that didn't involve Joseph Freeman,
To
correct?
my knowledge, no.
Okay.
That's all I have nothing further for Detective Thompson, Judge.
Any objection to Detective Thompson being excused?
No, Judge.
Oh, man.
Thank you, Detective. You're excused and you're placed under the rule and you know.
Yes, ma'am.
Mr. Coleman?
State calls Sergeant Jesus Tamayo.
Good morning. Do you swear or affirm that the testimony you're going to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat. You may proceed.
Thank you, Your Honor. Would you please state your full name, Sergeant, for the court reporter and for the ladies and gentlemen of the jury?
Jesus Tamayo.
And Sergeant Tamayo, how are you employed, sir?
I'm employed as a police officer with the Beaumont Police Department.
And how long have you been with BPD?
31 years, going on 32.
And you are a certified peace officer?
Yes, sir.
Back on March the 28th of 2022. Were you involved in the investigation or an incident involving a unauthorized use of a motor vehicle or stolen motor vehicle?
Yes, sir, I was.
Several individuals were arrested related to that offense, is it fair to say?
Yes, sir.
And who did they include? And if you need to refer to your report or a report, it's up to you.
If I may, one of the subjects was Raquel West, 23 years of age at the time. Charles Freeman, 19 years old at the time. Kalen Johnson, 16 years old at the time. Javon Johnson, 14 years old at the time. And Trevor Green, 14 years old at the time.
Ron Babineau, Charles Verdine, and Halen Johnson. Those are the three I kind of want to focus on. In the course of your investigation or the investigation, was Ronald Babineau, Charles Verdine, and Halen Johnson linked to an incident that happened the day before on March the 27th of 2022?
Yes, sir, to my knowledge it was.
Generally speaking, that incident would have been a what?
It was a homicide.
At the Virginia State's
Correct. 4250 West Virginia.
During the course of your investigation or the investigation, were these three individuals linked to a particular vehicle?
Yes,
Would that have you, if you have a description, that's fine. If not,
I don't have the description, but I know it was a small sedan.
what kind of color?
I believe it was like gray or beige. Don't recall the color.
Would you recall it if you saw it?
Yes,
The record on publishing states 26. Thirteen oh three 27 2022 1927. Does that vehicle, from your recollection, resemble the vehicle that Kalon Johnson, Charles Verdine, and Ronald Babineau were associated with?
yes, sir.
In fact, it was not only associated with that homicide, but that vehicle was also linked to or associated with the UUMV or unauthorized use of a motor vehicle the following day, right?
That is correct.
And when those individuals were arrested in or around that stolen vehicle, what, if anything, was found in that vehicle?
There were several guns found in the vehicle.
Okay. Judge, I was just handed some information that I need to show this witness. And we just got it. Can we take a brief recess, please?
Can I see?
We'll do it on the break. So, ladies and gentlemen, let's take about a 15-minute break. It's 10:20. We'll try to get started at 10:35. Please keep in mind all those instructions you were previously given. For everyone else, would please remain seated. You're excused for 15 minutes. All right, let the record reflect the jury's outside the courtroom. Mr. Coleman.
Judge, what I have here are photos from the scene that evening of the stolen vehicle that Sergeant Tamayo made the scene. In prepping Sergeant Tamayo this morning, he was forthright in saying that he doesn't necessarily recall the description of the type of firearms that were found. What we did this morning is we had to unzip the file, or it's very voluminous, unzip the file that contained all of those all the body worn camera, all the photos from the scene, which by the way, were turned over in discovery. But we had to unzip it and we just got it unzipped. We just got them printed. And I want to show these photos to Sergeant Tamayo to see if it refreshes his recollection about what the firearms looked like that day.
And all of this was in discovery that you.
Yeah, I mean, I've got a stat.
Sure, yeah, if y'all let
Yeah.
let Mr. Radford look at it as well, and I'll
Yeah.
take a short break.
I recognize.
All right, we'll be in. Okay, back on the record, state's attorney's present, defendant, and defense counsel are present. Anything we need to take up before we bring the jury back in?
No, Judge.
Mr. Radford?
No, ma'am.
All right, you can bring the jury in.
Mhm. Yeah, I don't want you to go there.
Let the record reflect the jury seated, state's attorney's present, defendant, and defense counsel are present. Mr. Holman, you may proceed.
Sergeant Myers, refresh the jury's recollection. We talked earlier about the scene of the stolen vehicle, what we refer to as unauthorized use of a motor vehicle or UUSV. I referenced that happening the next day after the murder or the homicide. In fact, what is the more accurate time frame on that?
The homicide was reported around 7:30 p.m. on that Sunday. The theft of that GMC was reported about 11:30 p.m. for the same night.
Okay.
The time where last part of the vehicle was about 1:30 in the morning, which was about 2 hours after the truck was reported stolen.
So to say that it actually happened the next day is not necessarily correct. That would leave the impression to some, maybe like it was 24 hours later. But in actuality, we're talking about how much time?
Total from the homicide to 1:30 was about 7 hours, was 6 hours.
So 6 or 7 hours prior, you had Kaylon Johnson, Charles Verdine, Ronald Babineau, and the defendant, Joseph Charles Freeman, in that silver Infinity. And then 6 or 7 hours later, you had all but Charles Verdine and the defendant in that stolen vehicle, right?
That's correct.
And in that stolen vehicle, there were certain firearms.
That's correct.
May I approach the witness, Judge?
Yes, sir.
I'm showing you what I've previously marked as State's Exhibits 56 through 84. If you can flip through those very quickly and just let me know if you recognize them. I might. Do you recognize those?
Yes, sir.
Do you recognize those as photos from the scene of the UU video of the stolen vehicle, where those individuals, Charles, excuse me, not Charles, but Ronald Babineau and Kaylin Johnson were arrested?
That's correct.
Are they fair and accurate photographs, including the scene, the vehicle, and the contents of that vehicle?
Yes, sir.
They don't appear to be altered or manipulated in any way.
No, sir.
Just state office states 56 through 84. During the break, I previously attended them to defense counsel for his inspection. They were also provided with discovery.
Judge, I remember seeing them in discovery. Let me just go over these real quick if I can.
Okay.
Judge, I'm going to object to these at this time under relevance because these, again, these weapons have not been tied to the murder. I mean, if he's identified them, but there's been no evidence showing that these guns were connected to the shooting of Richard Shiloh.
The state's position is it may very well go to the weight of the evidence, but the jury, based on the evidence, the testimony in those videos, can infer that these, particularly that long gun, well, both firearms are associated with the murder. The handgun was used, at least arguably, to shoot and kill the decedent, and that long gun was the gun that was arguably taken from the decedent.
If I could respond, there's no ballistics showing that these weapons were tied.
Overruled, 56 through 84 admitted.
Thank you. Permission to vote just a few of these, please.
Yes, sir.
Sergeant Jemiah, for the record, I'm publishing state's exhibit number 56. Is this what is this?
That's appears to be the 2014 GMC pickup truck that was stolen.
State's 57. That's just another shot of that pickup truck.
Yes, sir.
Inside of that pickup truck, state's exhibit number 58. What was located inside of that pickup truck?
There's some guns in there.
And is it fair to say that's a backpack?
That is it.
Okay, and then inside of that backpack states 60. What does that appear to be?
It looks like a pistol. Hang on.
States exhibit number 67. A little further in that backpack, what does that appear to be?
Like a mini Draco.
And once those items were pulled out of the backpack, were they photographed?
Yes, sir.
And is state's exhibit number 70 a photograph of the the handgun, at least the pistol that was found in that backpack?
Yes, sir.
Is state's exhibit number 67 another shot of that well, how would you characterize that firearm?
That's a long gun.
If you know, well, maybe a photograph and show better detail. State 77, is that another shot?
Yes, sir.
State's exhibit number 81. If you can make out the writing there on that firearm, what is that?
That's a mini Draco.
Now, yesterday, crime team tech, Anissa Barnett laid the predicate or foundation for the admission of certain photographs that she took back at the PD of firearms, and I want to show you the serial numbers from those photographs, if I may, and ask that you compare them to the serial numbers for these two firearms. So what I'll hand you is what I pre-marked as state's exhibit number 37 and pre-marked as state's exhibit number 35. I'll hand you that first. I can approach with these two.
Sure.
Okay. All right, 37 and 35, that's from Anissa Barnett. And these are from the photos that you've admitted through your testimony.
Yes, sir.
Hold on a second. I'd ask that you compare them to what has been admitted into evidence as state's exhibits number 72 and 81, and take a moment to compare the serial numbers on them. I'll hold on, wait.
They're the same.
Which would lead you to believe that the photos that Anissa Barnett took are the same firearms that were found on the scene there at the UUMV or stolen vehicle scene.
That's correct.
Now, at this time, the state would re-offer, make sure I've got my numbers right here. I think it started with 33. And it did, well, 34, 35, 36, 37, 38, 39, 40. The state would re-offer states 33 through 40.
I'm gonna renew my objections that he hasn't tied these weapons to the shooting of Richard Shiloh.
That's overruled. States 33 through 40 are admitted.
I believe that's all the questions I have for Sergeant Tamayo. I'll pass the word.
Thank you, Mr. Coleman. Mr. Bradford?
Sergeant Tamayo. Talking about the unlawful use of the GMC truck, is that correct?
That's correct.
And that's was, yeah, I think you said 6 or 7 hours after the shooting of Richard Shiloh.
Yes, well, actually, it was reported about 11:30 p.m. So that was about 4 hours after the homicide.
And in that truck were Ronald Babineau, correct?
Yes,
Charles Verdeen,
yes,
Kalen Johnson,
yes,
and then 2 juveniles, the Jervis and somebody else Johnson.
yes.
Charles Freeman wasn't, Joseph Freeman wasn't in that truck, was he?
No, sir, he wasn't.
Was it ultimate? Did you work on the murder of Richard Shiloh?
I was a sergeant. I assigned that case to a detective. So I was there I was one of the first ones that arrived there from CID. But
Did you work on the investigation?
no, sir.
Okay, who did that?
That was Detective Tamora Hamilton.
Was it ultimately determined that Kalon Johnson was the one that shot Richard Shiloh?
I believe so. I don't recall the specifics of it, but
Who would know
Yes.
that?
that was the Detective Hamilton.
Detective Hamilton.
Yes.
Pass the word.
Nothing further, Judge.
Thank you. Any objection to Sergeant Tamayo being excused?
No, man.
No objections.
Thank you, Sergeant. You're excused and you're placed under the rule and you know that.
Yes, sir.
Thank you, sir.
Thank you, Judge.
Just about to have just a moment, please.
Yes, sir.
Yeah, this time the state of Texas race.
All right. Thank you, Mr. Coleman. Mr. Radford, are you ready to proceed?
Judge, I have a motion.
So y'all come up for a second, please. Gentlemen, what we're going to do, I'm going to give Mr. Rapper, we have some legal issues to take care of, and then we will get started again. I'm going to go ahead and we're going to break and have a long lunch, and y'all are going to have a long lunch. We're going to make sure and work on the charge of the court that I talked about before. I've already been working on it. There's a lot that's going to go into it, and so we're going to make sure that's ready so that when we get to the appropriate time, we can go straight into me reading that to you and not have to take another break for it. So it's 11, we're gonna break until 1 o'clock. So just keep in mind all those instructions that you were previously given. If everyone else would please remain seated, we'll see you back at 1 o'clock. All right, let the record reflect the jury's outside the courtroom. Mr. Bradford?
Judge, at this time, the defense would move for an instructed verdict on the grounds that not a single person has identified this man as being at the scene. There's been not a single witness that said this man sitting right here was involved in this incident. Now, there's some testimony from a prior proceeding, but nobody identified him. And there's been no evidence that anybody, that Mr. Freeman was engaged in organized criminal activity.
Well, the organized criminal activity part is only one of the paragraphs.
Right.
So obviously there's the other paragraph. And so with regard to that, that'll be denied on that basis. With regard to identifying the defendant here, Mr. Coleman,
There's the defendant himself through the sworn testimony that was admitted evidence identified himself as wearing those black and red pants on the video.
Yeah, but nobody identified this man as him.
The defendant himself, Judge, it was read into the record that this defendant provided sworn testimony in a previous proceeding.
I'm going to deny the motion on that basis as well. Anything else, Mr. Rafford? Do you want to visit with your client? Do you need to put anything on the record with regard to?
Can I have a moment?
Yeah, sure.
Advise you to search your Fifth Amendment. Maybe you want to do that this time, not that. Yes, sir. Judge, my client would like to assert his Fifth Amendment right to not testify. Is that correct, Mr. Freeman?
Yes, ma'am, Your Honor.
Okay, you do not want to testify and you understand that you have a right to testify, but you don't want to.
Yes, ma'am, Your Honor.
Thank you. Anything else then before we kind of break, get off the record, talk about the charge a little bit off the record, and then we can get back on for whatever we need?
No, Judge.
For clarification purposes, did you deny my motion with regard to count 2, the indictment regarding the organized criminal activity? That there's been no evidence showing that he was engaged in organized criminal activity?
I did, because I think that's just a jury question, and because there's 2 counts, I'm going to, yes, I did.
Deny both of them?
Yes, thank you. All right, let's go off the record. With regard specifically to the third theory, which is paragraph 2 in the indictment really alleges 2 different theories. I think it could have been 3 paragraphs instead, but we're going to treat it as 3. With regard to the engaging in organized criminal activity theory, I went back through the only evidence that's been discussed and that I can recall from the trial that had anything to do with whether or not there was an aggravated robbery or there was going to be a drug riff or whatever it was. And I've gone through the transcript that was read, and there is absolutely no evidence of it. The defendant, every single question that said, you knew you were going to go rob them, right? Nope. We were going to buy drugs. We weren't going to rob. We weren't going to rob. I think he said it. I think I counted 5 times. He never, ever admitted that there was any type of robbery that he knew of. And so I think, unless I'm missing some other direct evidence that says there was someone who said there was going to be a robbery, Mr. Coleman.
Judge, I think there's evidence that the jury can use to infer that there was a robbery, notwithstanding what the defendant said. The jury can discount what the defendant said. He has a motive, a reason to lie. But the video shows, he says they went there to buy drugs. The video shows a shooting and them fleeing with what we argue is a firearm. And the officers have testified that there was no drugs in the vehicle when it was inventory. So I think there's enough evidence there to argue that because of the absence of drugs that they went there to buy, that would they can infer that it was stolen.
Mr. Radford.
I agree with you. There's no evidence of aggravated robbery. When all the witnesses testify, when he's leaving, he's carrying what looks like a long thing, which could be a gun. It doesn't show that they have drugs. It doesn't show that they went there to steal drugs. Their witness, the victim's girlfriend, said that there was some kind of heated argument. And then she heard.
Well, she did not say there was a heated argument. She specifically says she did not hear a heated argument.
Well, she said that he was cursing.
Yeah.
He was cursing.
But that was it. Just him saying the F word. There was no argument.
But there's no evidence of robbery. There's only evidence of a lack of robbery.
I am at this time going to reconsider Mr. Radford's motion for an instructed verdict with regard to the third theory, which is the last sentence of paragraph 2. And I'm going to grant the instructed verdict on that that theory or that count, however we want to call it, specifically with regard to the engaging in organized criminal activity. So that being said, that leaves us with the intentional and knowingly, and then the act clearly dangerous to human life. Both of those in the charge will have party and co-conspirator. Other than that, and I can do it, I believe the name in this one, different than Ronald Babineau's with regard to the party liability would be filled in with Kaylin Johnson. All of those blanks where it says name of primary actor. Do y'all both agree?
Yes, Judge.
Yes, ma'am.
And also name of co-conspirator, same there would be Kaylin Johnson, correct?
Yes.
And so with that, what else? I need to take out, I'm taking out,
Are you using the Babineau charge?
well, I guess I can, no.
Because it's,
Does it have both? Hold on.
this charge has the robbery.
No, because there was evidence in that trial with regard to, I can't remember who testified, if it was one of the co-defendants or someone. There was some specific evidence, or at least there was not an objection or a motion with regard to evidence on the aggravated robbery. There was something more direct in that trial, if I recall, that had to do with the robbery.
Quite honestly, I don't think so. I think we had essentially the same evidence in the Babineau trial with regard to the robbery as we have in this trial. It was all argument. I remember specifically making that argument to the jury about drug rip 101 and who goes to this to do this without bringing a gun, that kind of thing. I mean, I understand, of course, ruling, and I'm not trying to.
Yeah, I just think there was, there had to have been something different, and or there was not a motion specifically with regard to that. So no, I'm not even going to use that because that is all based on, that charge is all based on that. So the charge that we've got.
We have co-conspirator language in here.
Yeah. We've got party and co-conspirator, but we're going to need to have that in both paragraph 1 and paragraph 2. So we're going to have to say,
Taking out robbery or felony offenses.
yeah. Well,
It didn't make
no,
sense.
it doesn't. Hold on.
Take that out. I mean, what's the motivation? It didn't just.
There's no evidence. You say
There-
murder is a felony offense.
I maintain that there's evidence taken for judge.
So I need to change the whole thing somewhat because it is now the clearly dangerous and not all of this. Y'all give me a minute because now I'm. Okay, let's go back on the record. State's attorney's present, defendant and defense counsel are present. At this time, I'm not going to change my previous ruling with regard to the request for a directed verdict. We are where we are with regard to that. With regard to the jury instructions and the charge that you guys, the draft that has been given to you, containing only the single paragraph 1 of the indictment. Are there any, at this time, any objections, corrections, or requested additions from the state?
Sorry.
from the defense?
As long as my error is preserved with regard to my motion for directed verdict, I don't have a problem.
Okay, thank you, it is. How long would either of you request for closing?
10 minutes.
15, maybe 20.
Okay, I'll let you know if you get
I'm not
past
gonna-
that. You can bring the jury in.
Judge, I did have one.
Hold on.
Typo I found.
Well,
This
that's the correction that I just asked for.
That if you look on page 5, under in Jefferson County Honor about March 27th, 2022, that Kalon Johnson.
Thank you, that's what I'm asking there. And did I spell that right? Kalon Johnson spelled correctly, correct, right?
I think so.
Looks right to me. Yeah.
Okay, so I just changed the to that on page 5. Anything else?
That's all I saw. Judge.
I got it, good enough. Thank you. All right, now you can bring the jury in.
Need to rest.
Okay, yeah.
That doesn't mean I need to take a nap. No, I would like to.
All right, let the record reflect the jury is seated. Thank you for your patience. State's attorneys present, defendant and defense counsel are present. Mr. Radford, are you ready to proceed?
Yes, Your Honor, the defense rests.
Okay, thank you, Mr. Radford. So ladies and gentlemen, what that means is that at this time you have all of the evidence that'll be presented. The next thing is for me to read the court's charge and then you'll hear closing argument by counsel. I'm going to read the charge to you now. Cause number 24, DCCR 0348. The state of Texas versus Joseph Charles Freeman. Jury instructions. Members of the jury. The defendant, Joseph Charles Freeman, stands charged by indictment with the offense of murder. Bless you. The defendant has pleaded not guilty and you have heard all of the evidence. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable in this case. General principles. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after a careful and impartial consideration of all of the evidence and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that's in dispute. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state has not proved the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand, or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use the form attached to these instructions. The foreperson should sign the line that corresponds to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Law specific to this case. The state accuses the defendant of having committed the offense of murder. Specifically, the accusation is that the defendant is guilty of murder by either intentionally and knowingly, intentionally or knowingly causing the death of Richard Shiloh by shooting Richard Shiloh with a firearm. Primary actor liability. First, the state contends that the defendant, by his own conduct as a primary actor, committed murder. Party liability. Second, the state contends that Kaylin Johnson committed murder, and the defendant is criminally responsible for this offense as a party because the defendant solicited, encouraged, directed, aided, or attempted to aid Kaylin Johnson in committing it. Relevant statutes. Liability as a primary actor. A person commits the offense of murder if the person intentionally or knowingly causes the death of an individual. The defendant acts intentionally as required by this offense if it is his conscious objective or desire to cause the result of death. A defendant acts knowingly as required by this offense if he is aware that his conduct is reasonably certain to cause the result of death. Responsibility for conduct of another as a party. A person who does not by his own conduct commit an offense may nonetheless be criminally responsible for the conduct of another person. A person is criminally responsible for an offense committed by the conduct of another if, acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. A defendant acts with intent to promote or assist in the commission of an offense when it is his conscious objective or desire to promote or assist in the commission of the offense. A defendant's mere presence alone will not make him responsible for an offense. A defendant's mere knowledge of a crime or failure to disclose a crime is not sufficient. A defendant is guilty of an offense committed by another under the law set out here, even if that other person has been acquitted, has not been prosecuted or convicted, has been convicted of a different offense or of a different type or class of offense, or is immune from prosecution. Definitions. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt that the defendant is guilty of murder, either as the primary actor or as a party. Liability as a primary actor. You must determine whether the state has proved the defendant committed the crime by his own conduct. To prove this, the state must prove beyond a reasonable doubt 2 elements. The elements are that 1, in Jefferson County, Texas, on or about March 27, 2022, the defendant caused the death of an individual, Richard Shiloh, by shooting Richard Shiloh with a firearm. 2, the defendant did this intentionally or knowingly. If you all agree the state has proved beyond a reasonable doubt both elements 1 and 2 listed above, you must find the defendant guilty. Liability as party. If any of you fail to agree the state has proved beyond a reasonable doubt both elements 1 and 2 listed above, you must next decide whether the state has proved beyond a reasonable doubt that the defendant is guilty because he is criminally responsible for the commission of a crime committed by the conduct of another person. This is the case if the state has proved beyond a reasonable doubt 4 elements. The elements are that 1, in Jefferson County, Texas, on or about March 27th, 2022, that Kalen Johnson caused the death of an individual, Richard Shiloh, by shooting Richard Shiloh with a firearm. 2, Kalen Johnson did this intentionally or knowingly. 3, the defendant solicited, encouraged, directed, aided, or attempted to aid Kalen Johnson to commit the offense of murder. And 4, the defendant acted with the intent to promote or assist the commission of the offense of murder by Kalen Johnson. If all of you who did not find the defendant guilty as the primary actor agree that the state has proved beyond a reasonable doubt each of the 4 elements listed above, you must find the defendant guilty. If you all agree the state has failed to prove beyond a reasonable doubt either element 1 or 2 listed above establishing the defendant's guilt as the primary actor, and has failed to prove beyond a reasonable doubt 1 or more of elements 1 through 4 listed above establishing the defendant's guilt as a party, then you must find the defendant not guilty. You need not be unanimous about the theory underlying your guilty or not guilty verdict. If you all agree the defendant is guilty either as the primary actor because the state has proved elements 1 and 2 of primary actor liability beyond a reasonable doubt, or as a party because the state has proved elements 1 through 4 of party liability beyond a reasonable doubt, then you must find the defendant guilty. If you all agree the state has failed to prove beyond a reasonable doubt either element 1 or 2 of primary actor liability, and has failed to prove beyond a reasonable doubt 1 or more of elements 1 through 4 of party liability, you must find the defendant not guilty. Aren't you glad you're going to have a copy of that? Yes. Then that has my signature line, and then the last page is the verdict sheet. It reads at the top, verdict, not guilty. We, the jury, find the defendant, Joseph Charles Freeman, not guilty. And there's a line for the signature and then the printed name of the foreperson. And then below that, verdict, guilty. We, the jury, find the defendant, Joseph Charles Freeman, guilty of murder as charged in the indictment. And again, there's a line for the signature and then the printed name of the foreperson. Mr. Coleman, you have the right to open and close closing arguments.
Thank you. Your Honor, the state at this time waives its right to open. However, we will reserve our right to close.
Thank you, Mr. Coleman. Mr. Bradford, you may proceed.
Remember, this has been a very short trial. Remember Monday, we talked about the state having to prove all of these elements beyond a reasonable doubt. And they do that because if you're going to put a young man in prison for a long, long time, you better have really good evidence. I'm going to ask you a question right now and you can't answer, but just answer to yourself. Who killed Richard Shiloh? Who did the state prove killed Richard Shiloh? Who? Now it's in the charge, it says Kalen Johnson. And we know from Detective Tamayo that Detective Tamayo pulled over or arrested Kalen Johnson and some other guys for stealing the car. And that they had some guns in the car. Where are the ballistics? Why did not they tie these guns to the death of Richard Shiloh? Who is Kalen Johnson? We didn't hear anything about Kalen Johnson killing Richard Shiloh. Why? Because they have to prove that first. They have to prove that Kalen Johnson committed murder if they're going to prove that Mr. Freeman helped him do it, aided and abetted. And they haven't done that. What evidence have they brought you? There are 3 verdicts I submit to you. There's guilty, there's not guilty, and they didn't prove it. Because that's their job, is to prove it beyond a reasonable doubt. And they didn't prove who killed Richard Shiloh. We don't know what happened. We have a video, but we don't know what happened in that car. We don't know if Richard Shiloh pulled his gun out. We have evidence that Joseph Freeman was shot. And then we have evidence that somebody, they haven't identified that other person, shot Richard Shiloh. And then you have to ask this question. Assume that Kalen Johnson, again, who we don't know, intentionally or knowingly caused the death? Did Joseph Freeman give him that boost up to the window that Mr. Coleman said? Did he do that? Because there's something in the charge that I want you to read. It's on page. Where is it? It's on page 4, very bottom. A defendant's mere presence alone will not make him responsible for an offense. A defendant's mere knowledge of a crime or failure to disclose a crime is not sufficient. A defendant's mere presence alone will not make him responsible for a crime. What evidence have they brought you that this young man helped whoever it was that killed Richard Shiloh? Nothing. Nothing. There's a video of some kind of altercation that happened in about 10 or 15 seconds. And I would submit to you that that's not enough evidence to prove a murder charge. That's not enough evidence to prove that this man intentionally or knowingly killed Richard Shiloh, or he helped this unknown Kalen Johnson kill Richard Shiloh. Because you've got to have better evidence than this to put somebody in prison for a long, long time. And I would submit to you that it's just not there. They haven't met their burden of proof. There's so many holes in this bucket that the water's just pouring out of it. And this man is not guilty.
Thank you, Mr. Radford. Mr. Coleman?
Thank you, Honor. Mayor, peace of court, Mr. Radford. Ladies and gentlemen of the jury, I want to begin the way I began during our jury selection by thanking you all for being here. Thank you for your time and your attention on behalf of the district attorney's office, on behalf of our community, and most importantly, on behalf of the victim in this case. The victim in this case, Richard Shiloh, you heard the testimony. He was no angel. He was no saint. It was unfortunate that he sold drugs, but selling drugs is not a death sentence. He should not have died as a result of a poor decision that he made to sell drugs. Like we talked about during jury selection, I want justice for Richard Shiloh. A couple of things I want to point out in the jury charge, and you will have a copy. You can take it back with you and you can read it for yourself. It says that you are permitted to draw reasonable inferences from the evidence. That's what I'm asking you to do. It goes on to say that you can use your common experience to do so and your common sense. Most important, your common sense. I mean, if you think about what we talked about in jury selection, that jigsaw puzzle and wanting to have all the puzzle pieces, but if you've got enough of the pieces there, using your common sense based on the evidence, then that's enough, ladies and gentlemen. I mean, think about it. Defendants who are planning or conspiring to rob.
Objection, Your Honor. He's arguing facts, not into evidence. There's no evidence of robbery.
Thank you for being a fair judge, but I'll rephrase.
Thank you.
Defendants who are planning to murder someone in order to take their property.
Objection, Your Honor. Again, that's just.
It's closing argument. The jury will read the charge.
To take their drugs or their firearm, they aren't going to have a signed contract that I can bring in here and show you. Look, they all signed a contract. They won't have a notarized agreement. Hey, by the way, this is what they plan. So by necessarily, you need to use your common sense to infer from the evidence. And what can you infer from the evidence? Well, one is you saw the video of where that driver, the getaway driver, parked. Why on earth would he go through the effort to make sure that he's parked out of the line of sight? You know, if this is just a legitimate drug deal, then, or not, is there such thing as a legitimate drug deal? If this was just a drug deal,
then why park out of line of sight? So that, Richard Shiloh couldn't see the car. In fact, you'll note that when everything goes down and this defendant and Caitlin Johnson starts running, they don't run back around through the apartment complex like they came. They take the most direct route to that vehicle. They run straight to that vehicle. So that's the first thing I'd ask you to use your common sense on. The second thing is, my goodness, if he didn't know that Caitlin Johnson was gonna shoot this guy, and it all goes down, shots ring out, and this guy's lying there bleeding, why on earth take his gun and run away with it? Who does that? Who does that kind of thing if they're shocked? Oh my God, what just happened? No, someone with a criminal intent, someone who was intended to take something or something or things, takes that firearm under those circumstances. They run to that vehicle and jump in as if it were the plan. Why? Because it was the plan. So I'm asking you to use your common sense, ladies and gentlemen. Mr. Radford, who, by the way, is a formidable advocate, he made the point that there is no evidence that Caitlin Johnson was the person that's shooting him. I submit to you, who shot the victim. I submit to you, there is evidence. The defendant's own words from that sworn testimony or that transcript that was entered into evidence. He said it in the transcript. He was there with Caitlin. Yeah, it's in. It's good. You can read it. It's in evidence. But I also submit to you that's a rabbit trail because regardless, he was there and he aided that other individual. The other individual, Caitlin Johnson, that he identified in his transcript, and his aid promoted and assisted, like we talked about during jury selection. Don't fault me for using an example about giving somebody a boost up to a second story window. It just was an example. There are other ways you can aid, assist, or promote somebody. One of the ways is, hey, when you do this, I'll do that. In other words, you point the gun, shoot the gun, and I'll grab these things. That's another way to aid, promote, or assist. Don't hold me or lock me into my example that I just used during jury selection to make a point. And speaking of shooting, I found it interesting. I didn't snap to it until actually while Dr. Kanan was on the stand. It was a close contact wound in the left side of that victim's Richard Shiloh's body. Think about it. If you're reaching in and you're going to shoot after some argument starts, that firearm, why on earth would it be pressed against that victim like that? I submit to you, you can use your common sense to infer, no, when that door opened, Caitlin Johnson put that gun against him, and he being shot, Richard being shot, turned so that his left side was exposed in order to kind of maybe shield himself. After being shot, then shot again in the back. I mean, again, these are all things that you can infer. It was only a matter of seconds. You can see it on the video. You can watch the video if you want. It wasn't even time enough for there to be an argument. They walk up to that vehicle, and in a matter of seconds, they're shooting and they're running off. Think about this. You heard from Alizé Ballard. She was on the phone with Richard at the time. I mean, excuse my language, a badass would Richard Shiloh have to be to argue? He's on the phone, he's brandishing his firearm, and then he's arguing with these guys. That was not the plan. Richard Shiloh was on the phone with his girlfriend because he thought this was just going to be a drug deal, and then boom, 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 get out of it. And that's how that happened. These are all things that you can infer from the evidence in this case. And I'm asking you to do just that. Use your common sense and don't get distracted or fooled. A couple other things and I'll wrap up. There's language in here about whether or not this defendant was the primary actor or the one that shot Richard Shiloh versus being a part, promoting assistant. I would submit to you that the evidence clearly points to his actions being as a party to this offense. I would submit to you that you don't spend any time on whether or not it was Joseph Freeman who pulled the trigger, who shot Richard Shiloh. Don't spend any time on that. I submit to you, just focus on the party language. Did he promote, assist in the commission of this offense? To do otherwise, to let this defendant skate on this offense would not be justice for Richard Shiloh. And I'm asking
that, based on the evidence, in this case and your common sense, that, ladies and gentlemen, oh, one last thing before I forget. I get it, he wasn't the shooter. But that does not absolve him from guilt or responsibility. That's something that, in the event you find him guilty, you can take into consideration during punishment, okay? But nevertheless, I'm asking you to find him guilty as a party to the murder of Richard Shiloh. Not because I say so, or because Sergeant Tamayo says so, or Detective Thompson says so. I say find him guilty because that's what he is. He's guilty for assisting and promoting in the murder of Richard Shiloh. Thank you, ladies and gentlemen.
Thank you, Mr. Coleman. So ladies and gentlemen, I'm going to give the 3 instructions to the bailiff, and she will get you situated in the jury deliberation room. You can select your 4-person and begin your deliberations. And so for the alternate, if you'll just wait right there, we'll give you your instructions. For the rest of you, you can go with the bailiff, and we'll be in recess until you reach verdict.